No problem.
Welcome, Rowan. Yeah, so we're just going to chat through some of the legal challenges we've been dealing with for clients and some prospects as well, actually. Just some of the things we've learned and some things that, for anyone watching that they could obviously look out for. So one of the things I think that's come up, and Rowan, you'll have firsthand experience with this, is just the challenges of evicting a commercial tenant.
Yeah,
Obviously,
sure.
commercial tenancies are, you would think, all in the same category, but they do vary a bit. People tend to use different lease agreements as well. They don't always get it done by a solicitor or a legal professional, which sometimes means they've got an internet-generated lease agreement, which can make certain aspects of the contract either unenforceable or just less applicable to their specific case. I think the one that I'm speaking of now specifically, the lease agreement makes provision for an abandonment clause, but abandonment's not something that's really a very tried and tested process or particularly applicable in commercial tenancies. And so it's quite a challenge just to figure out what the landlord's options are in terms of enforcing either the break clause, the abandonment clause, or just following the usual eviction process. And obviously that's now where we come in and we do the research and we ensure that they make the most educated choice possible. But it's just definitely something to look out for anyone who does lease out commercial property.
Yeah, I think to add to that, the one of the main distinctions are the contracting, whether the lease is contracted within the Landlords and Tenants Act or whether it's outside the Act. So that's one of the main distinctions between the types of commercial tenant agreements.
Yeah, no, that's an excellent point. Is definitely look for the legislation, and then also just on that topic, the jurisdiction as well. You do get the odd lease that's going to be treated differently in Scotland and Wales as to what it is treated in England. So just something to look out for. But yeah, absolutely right. And then I mean, the other challenge is knowing then what notice to use and what format to use, because there isn't a lot out there on what it is or which is the correct one, and generally the lease is responsible for detailing that. So yeah, obviously the legislation is one thing to consider, jurisdictions maybe another one, although most people tend to be in England, at least that we speak to, so it's not always that much of an issue. And then just maybe from day one make sure that your agreement is drawn up by someone who knows what they're doing, so that when you fall back on it, you're falling back on something that is enforceable. Yeah, so unfortunately contracts are not the gospel all the time, and people do have that impression. Another thing we've been working on for a client is actually just completing their particulars of claim. There's again something that Rowan's got quite a bit of experience with, so I'm glad he's joined us today. But just again, I think the issue with this one was they hadn't quite fulfilled the regulation set out in Rule 16 of the CPR.
Yeah.
So I mean, I don't know, while we've got you here, would you want to touch on some of what that was and where they fell short there?
Yeah, just to start, the Rule 16 requires that the claims made by the applicant are both concise and clear, so that there's no ambiguity for what the claim is by the party, like that's creating the particulars of claims. And some of the other important issues that pointers that the CPR touches upon are the calculation of interest, because the court, if someone's making a claim in money, you have to stipulate the specific amount as well as the type of interest that you're claiming. So whether that's going to be interest accruing under a contract or whether it's going to be statutory interest. So that's one thing to consider as well. And some smaller details, for example, the calculation of the interest, giving the specific amount, how long the interest is running, the starting point at which the interest runs. So there's quite a bit of information that the CPR Rule 16 requires. And unfortunately, if an applicant doesn't abide by Rule 16, the entire application can be struck out. So it's an extremely important rule to abide by.
Yeah, no, I think just on the conciseness, one of the challenges we've seen is people aren't specific with their claims, or rather they are specific, but then because it's in many cases as an individual, you're quite emotionally attached to the case, so you include pretty much all your grievances, even though they might not be closely related to the case. And so that's a very common mistake, unfortunately, is you're submitting a claim for, harassment, and you're instead also mentioning, well, fraud and things that have nothing to do with where they've actually harassed you or slandered you. It starts to become many cases in one, and that's something that doesn't always get treated very well by the courts you're submitting claims to. So just another area that we're able to help a bit there, I think. And then just in terms of some prospects we've had come through, we're seeing people who, their wives have been unfairly dismissed. So a lot of spoken to a lot of husbands speaking to me about wives. I'll explain in a second, but wives who've had issues with their employers saying that they, took too much leave and are now making a claim for wages that were paid, unfairly in the employer's opinion. And basically just the importance of knowing what's in your employment contract. So that's someone that we're looking to help just understand the situation as well. And what we'll always say is, the best thing to do is, if you are wrong in some way, sometimes it's good to just admit that and rather admit it and mitigate your losses, rather than get into a long drawn out battle. In this case, the prospect seems quite, they seem to have a good case and a bad employer or bad ex-employer. And then I don't know, this might be amusing to you, Rowan, but I shouldn't say amusing, but spoke to a gentleman today who's divorcing his wife, and she's claiming he owes her money for a visa application that he paid for, but he used the joint account, which was in both their names. So even though he'd funded the joint account, the account was in both their names, and she was under the assumption that when the visa application was rescinded, that it would be refunded directly to her rather than to the account it was paid from. And she's made a monetary claim against her husband for I think the amount was just over £3,000, trying to leave it vague. But yeah, so just another area where, sometimes things that really should be dealt with in an informal matter become legal. And then to nip that sort of thing in the bud, you want to immediately find what your legal position is, get some information, get some evidence to substantiate your position, and nip something in the bud before it becomes, drawn out, back and forth, someone submitting an online money claim, which you're having to dispute, and appear in hearings for. So just another situation we're dealing with. Otherwise, the legal team's doing some research into pet travel, got a couple other prospects we're working on, and that kind of sums up what's been at this stage a bit of a short week, and I'm sure next week there'll be a lot more on the agenda.
Yeah, agreed.
Right. Yeah, thanks for joining me, Rowan, and we'll see you again next week.
All right, thanks, Joshua.